I think firstly, Minister, I would acknowledge that this is probably quite a substantial piece of legislation. It is in many ways a huge body of work taken against the backdrop of really a dysfunctional industrial relations machinery in the state. And really, since my time being elected here and raising cases that people have brought to me, I'm aware that in many instances people were waiting maybe 84, 85 weeks for an appeal hearing. And in the context of, say, for example, an unfair dismissal case, in reality justice delayed is justice denied, and that person wouldn't have a snowball's chance in hell of their case getting their job back or anything like that. So I don't think any of us would disagree that the system needs to be radically reformed. The question obviously is this the right way? And I think we do need to look at it against the backdrop of what's going on in the economy overall. And I note the surveys that were done and produced in the last week that says in the Irish economy we have the highest number of low-paid jobs, the second highest actually after the United States. We have 130,000 people in low-paid jobs who would like to be in full-time jobs. We have an explosion of zero-hour contracts where basically people are shackled to their telephone awaiting a phone call to see could they get an hour here or an hour there in terms of employment rights. And it is the case that the race to the bottom is alive and well. And I would say that there is actually a difference between injustice and illegality, if the Minister takes the point. I mean, in some ways what we're looking at here is the last port of call. When a grievance or a wrong has been done, somebody seeks a redress to that situation. But really what we should be looking at is how do we create a climate where less wrongs are done and people don't have to seek recourse actually to the industrial relations machinery at the end of the day. And I would say that one of the reasons why we're in this situation is that the trade union movement has sadly abandoned much of what it was set up to do and has settled itself for negotiating for a few crumbs off the table rather than championing the cause of workers in this state. And I would be a little bit concerned maybe in some ways about the whole area of NERA. I mean, NERA were supposed to be proactive, if you like, in dealing with abuse of workers' rights. So if we're amalgamating them under this whole WRC system, where is the proaction taking place in terms of that, the workplace investigations and all the rest of it? I mean, I do think as well they're quite limited, even as they're currently constituted in what they can do. I'm thinking of the Greyhound example, when the Greyhound workers did come to us and we facilitated a meeting with those workers, with NERA, and I have to say the staff were incredibly professional, very, very helpful in their desire to help workers, but they were very hamstrung by the legislation as it was, and a lot of, I suppose, an unscrupulous employer would be able to very quickly find their way around NERA and sort of box things off that they weren't responsible by outsourcing unhealthy practices to a third party and that sort of thing. And I mean, we obviously had these issues on the floor of the House already about scenes reminiscent from, you know, on the waterfront of workers being picked up in car parks and all the rest of it, nobody knowing who they were, whether they paid taxes or anything. So I'm not sure whether this new legislation takes on board those situations, and how does NERA's investigative, proactive role be protected in a context of it being dissolved into basically a wider body. But I do think there are other areas that need a lot of examination, and I want to give maybe an example of a few of them, because one of the key problems has been the lack of enforcement of rulings that have come out of our industrial relations machinery, and there is no doubt that if this legislation is to be effective, we need to stand on its head, that system. And I want to give an example of one young man from my constituency. His story has been printed in the public newspaper, so there is no secret, and he knows I'm raising it here. But David Bell is a young man. He's 27 years of age, and he was working in the multinational corporation eBay. Now, mistakenly, he was brought into an investigation about fraud and PayPal and so on. This young man had no case to answer in that regard, so the employer basically reprimanded him for giving out two €25 vouchers to two aggrieved customers, and this was a system that they did. If a customer was dissatisfied, you'd give them a voucher. He did that in 2 cases. Management said it wasn't appropriate in those cases, and he was brought into a meeting without any representation. He was told he couldn't leave the meeting until he completed a written statement, parts of which were dictated to him by management, and told that he couldn't have a representative present. He was subsequently dismissed and described by the company as dishonest, unprofessional and fraudulent. Now, this young man took a case to the Rights Commissioner. The Rights Commissioner was scathing in his criticism of eBay, where the Rights Commissioner said that this young man was wrongfully dismissed and was subjected to coercive tactics, and eBay's position was seriously in breach of natural justice and fair procedure. The Rights Commissioner recommended a payment of €15,000 in compensation to the young man and a withdrawal of the dismissal letter. That was almost 9 months ago. This young man starting out his working life. Nothing has been done to rectify the situation. He hasn't been given any apology, he hasn't been given any compensation, and that letter has not been withdrawn. Now, this example could be replicated in many others that I could repeat here. If big companies are allowed to get away with this, what chance does a worker have in a smaller company? And what guarantees do we have, Minister, that this scenario will not happen under the new arrangement? Because unfortunately I don't have time, but I have a list of other citizens from around the country who've gone to the State's Industrial Relations Machinery, been awarded quite, definitive judgments in their favour, only to find out that they never get the money, they never get justice, the employer just shrugs their hands and walks away. And if this legislation is to be effective, then clearly that is something that we really need to address. I think we need to look at the whole system at the moment, whereby decent jobs and redundancies are taking place, only to be replaced by interns and low-paid jobs. Again, that's a bit of a sick joke, which needs to be dealt with. I'm conscious of time, but one area that I think is lacking and I think you need to address, Minister, is one that has been brought to your attention on a number of occasions, that of the interest which former employees have in being able to access the State's Industrial Relations Machinery, namely those who were part of an employment pension scheme, that after they leave their employment, things happen that affect their pension scheme that they have a very clearly defined and vested interest in, but because they're outside the employment, they're not represented by a trade union and they have no access to that. And that's most graphically illustrated by the situation in the Irish Aviation superannuation scheme, where almost 10,000 deferred and active pensioners in that scheme are being faced with an almighty hammering of their reasonable expectation they had about the standard of living that they would have in their retirement. But a process has been underway where the trustees are being empowered to change the terms of that pension scheme. An expert panel was convened, and both the deferred group and the pensioner group were prohibited from participating in that process. They couldn't access the LRC that came up with this mechanism, and yet their rights were undermined. Now, we know that organisations like RASA, the Retired Aviation Staff Association, there is a system in place whereby retired workers have vehicles to organise their interests, and there should be a way in this legislation where we can enshrine access to retired groups where very much their standard of living is affected so that they can access it. I mean, in the airport scheme at the moment, pensioners are being expected to lose 6 weeks' pay per annum as a result of changes that they had no hand, act or part on. So I would hope, Minister, that you would address this as well in the final stages of this document if we're to be serious about the new legislation actually being of benefit to workers. I think there needs to be a lot more work.